The European Union has converted environmental compliance into a mandatory border control mechanism. Under the Carbon Border Adjustment Mechanism, or CBAM, and the Corporate Sustainability Due Diligence Directive, or CSDDD, ESG reporting serves as a hard financial baseline for trade. CBAM is a system that taxes imports based on the carbon emissions generated during their production. The CSDDD is a regulation requiring companies to address human rights and environmental risks across their entire supply chain. Together, they have integrated sustainability data into the core of European customs and liability law. To maintain access to these regulated markets, suppliers across ASEAN are adopting a standardized reporting grammar. The primary tool for this stabilization is the International Sustainability Standards Board, or ISSB, global baseline. Specifically, the IFRS S1 and S2 standards are being deployed to create cross-border legibility for investors and auditors. This creates a specific assumption among compliance and procurement professionals that identical reporting templates carry identical levels of legal risk. But imagine a critical error exists within the data of both of these documents, specifically a material misstatement of Scope 1 emissions. Scope 1 refers to the direct greenhouse gas emissions from sources that an organization owns or controls directly. Template convergence does not equal accountability convergence. The legal and financial consequences of that identical reporting error are dictated by the domestic legal machinery that processes it. Relying on an ISSB-aligned report as a proxy for standardized corporate accountability is an illusion. It exposes EU-facing firms to unpriced liability. To understand why, we have to look at the comparative law concept of legal formants. This is the understanding that transnational standards are always recoded by local institutional habits, statutory rules, and administrative practices. We can map this recoding process using a diagnostic tool called the accountability channel. This is the specific institutional route a sustainability statement travels to be verified, challenged, and sanctioned. The first element is the vehicle. This is the formal mechanism through which the ESG information enters the domestic legal system, whether it is a statutory filing, a stock exchange listing rule, or a private contract. Next is the actor. This identifies the specific entity with the power to verify claims and initiate enforcement. The third element is the pathway. This describes the procedural environment through which those claims are contested and adjudicated. Finally, there is the sanction. This is the ultimate remedial consequence or penalty applied for non-compliance. Mapping these four elements provides a systematic way for an EU-facing firm to determine the actual reliability of a foreign supplier's ESG data. In Singapore, the legal architecture operates on a model of continuous calibration, driven by market regulators. Singapore's primary disclosure vehicle is a stock exchange listing obligation known as SGX Rule 711B, but it is reinforced by a hard statutory vehicle, the Carbon Pricing Act. The Carbon Pricing Act monetizes emissions data, converting it into a tax base. For large emitters, that tax is legislated to reach 45 Singapore dollars per ton of CO2 equivalent in 2026. Because of this structure, the enforcing actors are highly concentrated. Authority rests with the Singapore Exchange Regulation, or SGX Redco, and the National Environment Agency. This creates a pathway that is administrative and market-mediated. The system prioritizes rapid supervisory dialogue between the regulator and the firm, rather than adversarial courtroom litigation. The resulting sanctions are public censure, listing penalties, and direct financial tax adjustments. This concentrated setup creates intense supervisory speed. Instead of rare, explosive lawsuits, the market sees a steady stream of visible micro-corrections. However, there is a limit. The strict tax liability anchor only applies to carbon emissions. Social and governance claims are left to softer exchange discipline. Singapore's channel is built to force rapid corrections and tax compliance without triggering existential operational disruption to the firm. Thailand presents a different architecture, a model of episodic contestation grounded in administrative justice and civil law. Thailand's vehicle is a mandatory document called the Form 56-1 report. This vehicle reclassifies sustainability data. By moving metrics into the One report, Thailand integrates environmental and social performance directly into annual statutory financial filings. Consequently, the enforcing actors are dispersed. Authority is split between the Securities and Exchange Commission and the administrative courts. This creates a highly juridified pathway. It features administrative legality review, allowing affected citizens and non-governmental organizations to legally challenge state and corporate actions. This pathway allows stakeholders to bypass the securities regulator entirely and challenge environmental governance directly in court. The public sanctions here can be significant. Administrative courts have the power to issue injunctions that can suspend a corporation's license to operate. There is also a parallel private law track. Thailand's 2015 Class Action Act weaponizes the One Report's statutory nature. This exposes directors and executives to direct civil liability for material misstatements found in their ESG data. Thailand's channel is slower to mobilize on routine errors, but it possesses a remedial bite that creates profound legal and operational vulnerabilities when ESG data is found to be false. Let's run a stress test to see these two systems side by side. Our control variable is an industrial supplier that negligently underreports its Scope 1 emissions. In Singapore, detection is likely to happen through emissions measurement linked to the carbon tax. The error hits the system and enters a tight administrative correction cycle. The exchange issues a query, the tax base is adjusted, and the company publishes a public correction. The issue is resolved. Now watch the exact same error in Thailand. The error hits the statutory filing system and splinters horizontally across multiple institutional layers. On the public law side, civil society actors utilize the data error to file an administrative court challenge against the facility's operating permits. Simultaneously, on the private law side, shareholders utilize the statutory defect to initiate a class action lawsuit for damages. The Singaporean channel cleans the data. The Thai channel crystallizes questions of legality and liability. Because these two identical errors yield completely different institutional reactions, standard reporting templates cannot be used to gauge actual supply chain risk. This radar chart maps a jurisdiction's credibility profile across supervisory speed, enforcement visibility, and remedial bite. Singapore extends high on speed and visibility, but remains moderate on remedial bite. Thailand scores lower on speed and visibility, but spikes to the maximum edge on remedial bite. Neither model is inherently superior. Singapore protects market efficiency, while Thailand protects participatory environmental governance. But for EU-facing companies conducting due diligence under the CSDDD or CBAM, these differences represent critical operational liabilities. Due diligence teams must stop treating ISSB-aligned reports as fungible compliance signals. Legal and procurement teams must build channel-specific verification protocols, tailored to whether local failures trigger quiet regulatory queries or paralyzing class action lawsuits. Transnational ESG standards only provide the vocabulary of sustainability. It is the domestic enforcement architecture that dictates the actual cost of a lie.